Hey everyone, welcome back to the channel. In the last video, I mentioned I'd be covering the jury trial of the last sovereign citizen morons. Unfortunately, despite earlier claims, it was never streamed. But don't worry, I've got something even better lined up for you today. We're diving into two courtroom disasters instead, one out of Florida and the other from Washington. The first might be one of the most clueless individuals I've ever featured. And somehow, the second manages to top even that. Let's get into it.
I would have one of those. I don't seem to have. I hid it for myself and Mr. Gonzalez. You ordered to stay away from 150. These
Judge, he's not. I apologize for interrupting. He's no longer there. Corrections took him away.
okay.
Utilize my right to be heard, and I'm representing myself, Your Honor. I just got back from the last courtroom where I was RR'd. Are you ready to hear what I have to say, Your Honor?
I am.
All right, cool. So I would like to inform you, Your Honor, that there is two open lawsuits. One against this court system for wrongfully finding probable cause on police misconduct and violating my 6th and 14th Amendment and due process, which led to false imprisonment. Against the Miami Beach Police Department for multiple false arrests where they have violated my constitutional rights and multiple United States laws. This situation is very serious, Your Honor, because I now have to file another lawsuit for attempted murder and attempted vehicle manslaughter. I say vehicle manslaughter because these two police officers that followed and stopped me November 6th is the same two police officers that watched me park my bike on 10th and Ocean, pace back and forth next to my bike on 10th and Ocean, and then hit me off my bike while they ran onto the sidewalk, also hitting two other pedestrians. So that was vehicle manslaughter.
He says it was vehicle manslaughter because the same two officers who stopped him on November 6th were, according to him, the same officers who had earlier seen him park his bike at 10th and Ocean, circle back and forth, then drove onto the sidewalk, knocked him off his bike, and struck two pedestrians. That, he insists, was vehicle manslaughter. Vehicle manslaughter, he calls it. I hate to be the one ruining the breakfast special in your jail-issued tray, but manslaughter, by definition, requires someone to have died. And while your argument may be brain dead, you are very much still breathing.
They never tried to attempt to pull me over. Like the A foreman said, they tried to, that I tried to evade them. They tried to pull me over. Because if I tried to run away, why did I park my bike? And you see me park my bike on 10th Street. So look, let me continue. There's another one that I have to file for attempted murder because when they said, put your hands behind your back, they kept me, they prevented my hands from going behind my back while covering my face and mouth. That is attempted murder. So now let me start. November 6th, right? And I've had this bike since February. November 6th, these officers witnessed me talking to three girls or whatever. They followed me for 3 blocks and then took the same right turn that I took. And then I made a U-turn onto the sidewalk and then they stopped following me. Then they approached me when I was talking to my friend on a bike lane on Ocean Drive between 11th and 10th Street. That is when they wrote the ticket. And they said, if I don't walk my bike home, my electrical bicycle, then I'll be arrested. So I walked my bike home and then went back to the same officer, Officer Rivera, after I did my research. And I told him that because my bicycle has pedals, it is considered an electrical bicycle. So if you try to arrest me for riding my electrical bicycle, I will file another lawsuit against you. And then I rode my bicycle November 6th and no one said anything. I rode my bicycle November 7th. No one said anything. I've had this bike since February 8th. I've got pulled over for running a red light. I even called the sergeant. The regular officer and the sergeant never said my bike was not street legal. This was March. This was July where I got pulled over again. I requested the sergeant, the regular sergeant and the regular officer and the sergeant never said that my bike was not street legal at all. So what I'm saying is, to you, you have a judicial code of conduct. You have to follow the law at all times. It's your duty to follow the law. And based on the 14th Amendment, I have the right to be treated equally. So if they're not arresting DoorDash drivers, Uber Eats drivers for riding their electrical bicycle, you cannot keep me in jail for riding my electrical bicycle. This is what I explained to the judge previously, and I got RR'd. And the public defender had did their research. They found out that with a with pedals is still considered an electrical bicycle. And I even informed this officer, and he even seen me riding southbound. He made eye contact with me November 8th on Saturday. He made eye contact with me while I was driving southbound on Ocean Drive. If I was riding something illegal, right? If I didn't go back up to him and tell him that if he tries to arrest me for riding my electrical bicycle, he will be sued, why didn't he just pull me over? If what he said that happened on 9th Street, why didn't he pull me over? Why didn't he hop on his golf cart and pull me over? He did no such thing because that is a lie. He lied on the A form, and I'm proving it to you because I parked my bike down this 1 block away. So if I really tried to run away from the police, why did I park my bike 1 block away? And based on the fruit of the poisonous tree doctrine, anything that rooted from illegal activity cannot be used against me in the court of law.
Well, that's not exactly how the fruit of the poisonous tree doctrine works, as explained in Wong Sun versus United States. Essentially, if an illegal confession is taken or evidence is obtained unlawfully, you can file a motion to suppress that evidence, but it's not a free pass to walk out of jail. Also, I have to point out, you first claimed they knocked you off your bike, and now you're saying the bike was a block away. Until you get your story straight, your fruit of the poisonous tree defense doesn't hold much weight. So all the charges has to be dismissed. From riding with a suspended license, I don't need a license to ride my electrical bicycle. Vehicle registration, I do not have to register my electrical bicycle. And driving with a license suspended, I don't need to have a valid driver's license to ride my electrical bicycle. And this all...
Judge, on his traffic case, he received R.
Well, good. Anyway.
Yes, so what I'd like to say is that also Burger King is across the street from the police department. So no police officer can say that they don't see other electrical bicycles and other dirt bikes riding on the beach. So it's no excuse, not even just pouring it out that they lied on the A form. And it's also my workers. I even have a video. There was electrical bicycles passing by November 6th as they was writing me a ticket for my electrical bicycle, which was a blatant violation of my 14th Amendment. So they continue to write a ticket for my electrical bicycle as someone pulled over and said, "What's going on?" A restaurant worker that usually parks their electrical bicycle right there on Ocean Drive. You cannot be a police officer and say you don't see electrical dirt bikes riding on Ocean Drive and electrical bicycles riding on Ocean Drive, because there's 15-year-olds with electrical dirt bikes since last year that has been riding up and down Ocean Drive, and no one has said anything to them. So it would be a blatant violation to arrest me or harass me for riding my bike. So I would like to be all involved with this as well, because I'm not sure why it was divided into 2 judges at all. And the public defender already looked at the law. If you want to look at the law, based on the fact that my bike has pedals, is considered an electrical bicycle.
All right, then. So it sounds to me like you've already raised a misdemeanor, Judge, about your pedals and your electric bicycle. I myself am dealing with 4 counts of battery on a law enforcement officer, 1 count of resisting an officer without offering to do violence, 1 count of felony marijuana possession, and 1 misdemeanor arresting. So those are the cases I'm dealing with, not that whether or not your bike has pedals on it.
I'd like to include, Your Honor, that my older brother passed away because someone hit him off his motorcycle, 2016. I would never run away from the police.
Uh-huh.
And the fact that they waited till I hopped on my bike to try to hit me, to try to build a false narrative like I was evading them, is completely illegal. They waited till I hopped back on my bike after seeing me hop off my bike. So that is what? Vehicle manslaughter.
You're very much alive, and honestly very much a nuisance. So no, I don't think anyone's manslaughtered you. And now, the judge is about to give us her take on the situation.
So now I have to file another...
It would only be vehicle manslaughter if you were dead. But you are quite chatty for a dead person. So I really can't find that you're dead.
Why did they attempt to murder me? They covered...
Well, that's a horse of a different color. So what I have to deal with was what's written on the arrest affidavit, not your constitutional arguments, which may very well be filed in a different court on a different day. I have to deal with the 4 corners of the document there.
Yes, and based on the 4 corners of it.
Based on the 4 corners of the document, I'm going to find probable cause on counts 1, 2, 3, 4, 5, 6. And let me ask corrections. Was the resisting without violence dealt with in misdemeanor court or not? Well, that's
I would like to speak. Your Honor, if
Stop!
he,
I'm trying to get an answer from corrections as to whether or not the resisting without violence was managed misdemeanor court or not.
Your Honor, if I have to pay any type of bond, then I will file another lawsuit against this court system.
Well, alrighty then. Please feel free to do so. Probable cause is found on counts 1, 2, 3,
And the fruit of the poisonous tree doctrine,
and
that rooted from illegal activity, it cannot be used against me in a court of law.
well, that yes, it's
Understand that
the constitutional background for a motion to
law.
suppress evidence that was seized. I read that case once. So counts 1 through 4, the bond is $2,000. Count 5, the bond is just $1,000. Count 6, the bond is just $1,000. Count 7 is an ROR.
Judge Victoria Singular,
I am Judge Victoria Sigler.
not RR.
All right.
I will file a tort.
Please feel free to file whatever things you think are appropriate.
I always get a kick out of defendants who think threatening to sue the court will help. They usually just make things worse for themselves. Now, let's head to Washington, specifically Bellingham County, where we might have someone even more irritating than our first star.
This is case number 5A08688584. I did review the report that was completed and filed by DSHS. And does the city want to be heard at all?
City would ask the court to adopt DSHS's recommendations or findings.
Does defense want to be heard at all?
Yes.
Your Honor, we also ask the court to enter this finding, and we also ask the court to withdraw the assigned attorney due to breakdown of attorney-client relationship.
Yeah. And I would like to be heard on the record as well.
The court does adopt the report that was filed by
What does the report
DSHS
say?
finding competency in
Competent.
this case.
Is it uncomfortable? Okay, cool. Sweet.
That was by Western, right?
Yes, sir.
I'll check that box.
So now can I go through a full phoretic colloquy so that then I represent myself and you are no longer okay.
We're not going to do that today, though.
Well, I'd like to do that because I'd like to, not have the public defenders involved anymore in obstructing, my rights. And then two, I need.
Seems certain to the court that you need legal representation, so I'm not going to do that motion today.
No, I don't, because
Does the city want to be heard on this case?
can you answer this for me? I did a motion to revise the original anti-harassment protection order,
Yeah, that's
and
not before
four
the court,
or
sir.
5 different judges recused themselves on that. Are you aware of that motion to revise?
That's not before the court here today.
City,
And
No, but it's really relevant, right? Because there's no probable cause to arrest me and hold me for this charge.
found Mr. Spidell, so
Then I will, and it hasn't been presented to me. I haven't seen any probable cause affidavit or anything like that. And if you read the motion to revise the original anti-harassment protection order, you'd see that there was no evidence in that hearing of harassment. All I did was try to let the prosecutor's office know of Brady Giglio material committed by Crystal Chapel.
you are
Right?
being
Can you let me speak, please?
You're being recorded.
Yes, I want this to be recorded.
You're being recorded and you're making admissions that might be against your personal interest in this case.
No, that's not true because I'm 100. I want the truth to be known. I have nothing to hide. Okay, so
And we are
you guys are obstructing though. You guys are doing the obstruction here. Okay, so I want this to be heard on the record
Yeah.
that I've just reached out to the prosecutor's office to let them know about Brady Giglio material committed by Crystal Chapel, and I was concerned that maybe she would be involved in high-profile cases like the cop that I heard was killed, and I would hate to see anything overturned once this comes down the pipe.
Yeah, I'm sure you're not thrilled at the idea of your conviction being overturned over alleged Brady violations. Honestly, it's starting to sound like you already know you're guilty. After all, violating a protection order is usually one of the easier cases for prosecutors to win.
Focus in on your case and not using.
No, yeah, this is my case, right? I've been sitting here in jail for 60 days without probable cause.
Probable cause was already determined, sir, so you are not sitting.
It's not a smiling matter. No, then tell me what the probable cause was.
Occurred in this case.
City would ask to set for trial, Your Honor.
We're setting the matter for trial.
Okay. Then, ma'am, I think that you're outstepping your bounds and you're obstructing justice here. Because if you read that motion to revise the protection order, why have 4 different judges recuse themselves? Why did the gentleman just before you just recuse himself? You know, everybody's playing hot potato with accountability, but you're the only one who seems that.
And I'm not recusing.
You want to break the law.
Here I am.
Right, but you're not hearing me.
Oh, I am hearing you, sir. And what you're saying doesn't fit with the facts of the case. There was probably.
Then what are the facts?
And we're moving forward with trial. You'll get your trial on the merits, sir.
Okay, but I know that you guys are just going to dismiss it before trial happens because you don't want a jury to hear about all your misconduct.
Well, I don't mind the jury hearing what you perceive as misconduct. If it's
okay.
Anyway.
All right, then I'm looking forward to that.
If you let us have a moment, we'll set your trial date.
From my calculations, Mr. Speedle has been in. We have Speedy running from November 5th to December 8th when the order was entered for competency, and so after the competency was on today, we're running from. So it was 33 days. We're 33 days into speedy trial. So I believe if we set by January 27th, 2026, we would be within the 60 days.
Okay.
So
no, that's not true because I was arrested on October 28th.
Let's see about officer.
Today's day 59 or day 65, depending on how you look at it.
20th, we don't have a jury because of the holiday, and that complicates getting a jury. And the 13th is heard by a protest if it's set on the 13th. So we have the 6th and the 27th, which is pretty close to. You know, the 27th you said is within speedy, so.
I believe so. I'm going by what the jail records say of 11/3 as the booking date.
Okay.
Well, I object, you guys. Didn't you guys swear oaths to uphold the Constitution? Aren't you supposed to protect my rights and not violate them? Why don't I get a speedy trial?
I'm certainly trying to protect your rights, sir.
Well, then why are you even taking me to trial without probable cause? That's malicious prosecution.
I can't keep answering the same issue about probable cause. It's already been determined.
Well, then can you read to me, for the record, what the probable cause is? Because all in my records, I just see it says warrant, and warrant is not probable cause.
And probable cause is determined before a warrant is issued in this court.
So explain to me then what the probable cause is, why I've been sitting in jail.
And if you would work with your attorney, you would have all of that information.
I am my attorney.
But that's probably the dumbest thing you've said so far. No, you're not your own attorney. The woman standing next to you is. And she'll remain your lawyer until the court either assigns someone new or officially allows you to represent yourself.
So I'm working with you now. Tell me what the probable cause is for my arrest.
I'm not granted any motion where you're representing yourself, sir.
Okay, well, I don't understand how you can sleep at night with this kind of misconduct. I mean, like, you know, all your colleagues have passed the buck around, playing hot potato, recusing themselves. And you can't even tell me what the probable cause is. You just say that it's already been established. Well, that doesn't fly.
January 27th, 9 o'clock is your jury trial. Status. Do we set status on the Friday? On the Monday. Your status.
You're obviously not a Christian or a follower of Jesus Christ. I can tell that. And you're going to have to answer for this someday, ma'am. You will be judged.
January 26th at 8:30 in the morning for status. Readiness. January 12th, 8:30.
And what about you, Mr. Good? Where's my probable cause? Where's my discovery?
On the same dates, correct. All right, out of custody dates for those matters are the same, only at 1:30. I'll put a note in here for that.
Yeah, put that note in there.
Now, obviously the court wants Mr. Spidell to be represented through a jury trial.
No. I'm gonna represent myself.
Only if the court allows it.
Okay, well that's not fair, and that's against my constitutional rights. Okay.
Well within-
Yeah, you're holding me without probable cause, and then you're forcing me to have a public pretender who's not gonna uphold my rights, or is actually actively working against me.
Perhaps.
I'm sure.
If you're not willing to work with your current attorney, we can find a conflict counsel to assist you.
I want a speedy trial. I want to represent myself, and I want it today. Today is day 65 of my incarceration without probable cause. That's malicious prosecution, according to RCW 9.62.100.
But I can go through the colloquy, but we can have standby counsel at the very least.
No, well, yeah, I'll do standby counsel, but I want the phoretic colloquy, so I'm representing myself, so that then I can contact the prosecutor directly from the jail. I can get my discovery and everything like that.
It would be, I think, against his personal benefit to be
This isn't a joke, ma'am. Why are you laughing?
legal representation. You know, to present yourself in front of a jury the way you're presenting yourself in court would not be to your benefit. And you,
I beg to differ.
Well, you're clearly not a seasoned attorney handling cases regularly. You're just someone who thinks he knows better than everyone else because he wanted a protection order change and decided, allegedly, to do it himself.
sure you do. So, if we do go to trial on January 27th, which it's set for, I would encourage you to, at the very least, have standby counsel to assist you.
Okay. Yes.
So we'll try and find conflict counsel and in short order so that you can speak with an attorney about your jury trial, which is coming up now.
Okay, but in the meantime, I would like Mr. Good to provide me with my discovery and the probable cause affidavit, and also a copy of my motion to revise the original anti-harassment protection order.
That's
Thank
not
you.
for this court. That's a different court.
Man, this is a kangaroo court then.
All right.
You should be ashamed of yourself.
Your opinion.
Be that as it may, yep.
The discovery has been provided, and if you would work with your attorney, you would know all.
I am my attorney, ma'am.
You would know all that.
I want to work with the prosecutor because I'm representing myself. Okay?
Not at this moment. We are going to find you conflict counsel to assist you with the case.
No, I object. I object to that. I am fully competent enough, just like the 1077 found, right? That I'm competent enough to stand trial by myself.
Just because the court found you competent to stand trial doesn't mean you're competent to represent yourself. Like it or not, this is a court protecting your Sixth Amendment rights.
So if we are going to go through that colloquy and allow Mr. Spidell to represent himself with standby counsel, hopefully,
Yes.
I can do that now. So we
Yes, please.
Yes, Your Honor.
Thank you, God.
Okay, you have the constitutional right to represent yourself if you choose to do so. It must be knowing and voluntary. And I'm going to make clear on the record this colloquy that you wish to waive your right to represent yourself and that you're fully aware of the hazards that you may face and the disadvantages of self-representation. Do you understand that if you cannot afford to pay for an attorney, can only partially pay, that, and you have been deemed eligible at this point, that you can have conflict counsel take over this case with you.
I understand that I can request counsel, but I don't waive any rights, especially my right to a speedy trial, and I wish to represent myself.
The only way we're going to get through this colloquy and help me make a determination that you can represent yourself is if you answer the questions specifically.
Okay, then can you repeat the question?
I can, yes. Do you understand that you have been deemed eligible for a public defender? If you wish to, we can find conflict counsel to assist and take over the case with you.
Yes.
Have you ever studied law?
I have studied law, yes.
Have you ever represented yourself or any other defendant in a criminal action?
Yes, I have represented myself.
And have you ever, or do you know that you're charged at this time with the anti-harassment protection order violation, 2 counts on this case?
Yes.
You understand the charge? Okay. Do you know that if you're found guilty of these charges, that you could be sentenced up to, these are gross, right? 364 days in jail and a $5,000 maximum fine on each count?
Yes.
Do you know that if you represent yourself, you're on your own unless there's standby counsel, and that the court cannot tell you how you should try your case or even advise you on how to try your case?
Yes.
Do you understand that you have the right to have your guilt or innocence decided by a jury?
Yes.
You understand a jury consists of 6 people chosen from the community?
Yes.
Are you familiar with the rules of evidence?
No.
Do you know that the rules of evidence govern what evidence may or may not be introduced at trial? And if representing yourself, you must abide by these rules of evidence.
Yes.
Are you familiar with the rules of criminal procedure?
No.
These are rules that govern the way in which a criminal action is tried in this court. Do you understand that?
Yes.
And do you know that if you decide to take the witness stand, you must present your testimony by asking questions of yourself, and you cannot just take the stand and tell a story, your story?
Yes.
You understand you must proceed question by question through your testimony if you choose to testify?
Yes.
Why don't you want an attorney to assist?
Because they're not working for me, they're working against me.
Choosing not to have a qualified lawyer question you and the other witnesses, questions that could actually help your case, is the textbook definition of working against yourself. That said, I really hope his jury trial gets streamed so we can watch him awkwardly try to question himself.
Okay. Have there been any threats or promises that have been made to induce you to waive your right to counsel?
No threats or promises.
Do you realize that if you proceed without an attorney and you do not properly present a defense, subpoena witnesses, or otherwise represent yourself in a competent manner, that you will not be able to obtain a reversal of a conviction on the grounds that you received ineffective representation?
Yes, I'm aware.
All right. Then, again, the court would advise that you would be far better served by a trained attorney than you can be by yourself. You've already indicated that you're not familiar with the rules of evidence or criminal procedure. And the court would, again, strongly urge you not to try to represent yourself. But also in light of the penalty that you might suffer if you're found guilty of 2 charges, and the difficulties of representing yourself, is it still your desire to represent yourself and give up your right to be represented by a trained attorney?
Yes.
Is this decision entirely voluntary on your part?
Yes.
The court finds that you have knowingly and voluntarily waived your right to counsel, and you are permitted to represent yourself. However, given your lack of knowledge of the rules of evidence and criminal procedure, the court is going to assign standby counsel to assist you in this trial, and would encourage you to work with this counsel so that you can present your case in a proper fashion and according to the rules of evidence and criminal procedure. So we will attempt to find conflict counsel to assist you with the trial. There's a lot involved in preparing. You've indicated that you've represented yourself in the past. I'm not sure which case that would be when I'm looking at your criminal history, but in any case, you've indicated that to the court. So I have factored that into the determination that you can represent yourself. So as soon as we can find conflict counsel, we'll advise them to get in contact with you so they can assist you in the preparation of the case.
Okay, well, in the meantime, all the real assistance I would need is just a copy of the court rules.
Okay.
So if I could get that in, then I could study them, and I wouldn't need any assistance from an attorney at all.
Yes, because your next month in jail is definitely enough time to read and fully grasp the complex court rules that lawyers spend years mastering.
Okay. We will see what we can do about that. Is there anything else from the city's perspective that needs to be placed on the record today?
No, Your Honor.
And counsel or Mr. Spidell, anything else that you'd like to that hasn't already been placed on the record that you would like to have placed on the record today?
Just the fact that I'm still waiting on discovery. So if Mr. Good can please, get that to me in my cell, and also copy of the probable cause affidavit by any deputies working the case. And also I require a copy of my motion to revise the original protection order.
Again, that's not a matter before this court. We don't have jurisdiction on the original order.
No, well, I'm asking the court.
The one in this court.
Yeah, I did a motion to revise prior to my arrest.
The other orders are out of different jurisdictions. So that's count.
No, I did a motion to revise the protection order.
Whatcom County Superior. So the only one that we have jurisdiction over is the one that was entered in this court. So if that's what you're referencing, then we can certainly address that at some point.
Okay,
Discovery's
thank you.
already been provided. Did you want previous counsel to provide that to conflict, and
Yes.
it would have to be, reviewed for redaction and such?
Yes, Your Honor.
Okay. All right, we'll get the materials that we can to you and to conflict counsel once we have conflict counsel on board.
Well, in the meantime, I would like it to me, because I don't require conflict counsel, so I don't want that to hold up, me getting my hands on these documents.
We'll see what we can do. The court's closed tomorrow, just so you're aware.
Okay, but did my former attorney here, do they have the discovery and everything? So can't they just provide it to me?
As long as
So long as it's properly redacted, they should be able to provide it.
the previous
Okay.
counsel should
Can you
be able
provide that to me?
provide that, but counsel, you need to review for any appropriate redaction pursuant
Okay.
to the law.
You understand?
Yeah, I can.
Okay.
All right.
Okay.
Thank you, Mr. Spidell. Thank you, counsel. Thank you, Mr. Good.
Thank you, ma'am.
And then we're
You
going to
need to
switch
sign
to
here.
judicial office.
On that side.
Oh, this is a set for trial.
Well, I'd need to read it over before I sign it. So
All you're signing for is the dates
For
there.
the memories into.
okay.
Signing for the dates there, and also to abide by the previously imposed conditions of release. If bail.
Yeah, I don't agree. I object to the dates, because I want a speedy trial within 60 days. So I'm not going to sign that unless it's under duress.
Just, it's fine. You have notice of the dates.
No, it's not fine. So I'm not going to sign anything at this moment. Sorry.
For you not to sign. Counsel, if you want to put in there, refuse to sign, that's fine too.
Yeah.
Okay.
Thank you.
Thank you, man. Have a good day.
Bye. Have a great time.
It's been a while since I played that clip, but he really deserves it. Like I said, I'm really hoping they stream his jury trial, especially since they didn't show last week's pretrial readiness hearing. If they do, I'll bring it to you. If you enjoyed this video, hit like. If not, hit dislike. Don't forget to comment and subscribe with notifications on so you don't miss any content.